Insurance-related issues due to COVID-19, what every business should do now. Hi, I'm Bill Catras. I'm a partner at HMB, and I'll be going through some of the insurance-related issues that have come up due to the crisis that we are all facing, and what businesses, whether you are in retail, restaurant, manufacturing, what you should be aware of. Some of the key takeaways from my presentation today will be the following. Number one, the laws relating to your business interruption insurance is changing every day, and it is changing on a state level, federal level, even a municipal level. Number two, each insurance policy is different. Businesses need to read their current policies. Number three, be sure to look at your property insurance, business interruption, extra expense, and civil authority coverages. Another key takeaway is that businesses need to make their claims now. Also, businesses that potentially have a COVID-19 insurance claim should be tracking all their expenses and losses now. And lastly, I hope one of the main takeaways you'll take away today is whether you're working from home, whether you're having all your employees work from home, or you're starting operations back up, or you're about to renew your insurance policies, you have to think about the impact of COVID-19 on all those events. Threshold COVID-19 insurance concepts businesses need to understand. First, every insurance policy is different. I cannot tell you how often I get a business that is in the same industry as the last business that I consulted, that has the same insurance carrier, and presents me their insurance policy for business interruption, which is usually a property policy. And that policy has different terms than my prior client. So the takeaway there is the specific policy language is what matters, and not what you hear about your insurance from third parties, and especially what you hear on the internet or in the news media. Mainly, it's because we believe that insurance companies are using the internet to put out their legal arguments and to try to have that influence decision makers. The legal arguments that are being presented are not 100% accurate, and they may not be applicable to your industry, to your type of policy, and in the state in which you're located. Throughout my presentation today, you'll see links that have been inserted, and I encourage everyone to click on those links for up-to-date information on these issues, on the related issues, and I hope you find those helpful. The key argument that most insurance companies are discussing in their news media and online opinions is regarding the term physical loss or damage to property. And they're asserting that COVID-19 is not creating a physical loss to the actual business's property. How can it? It's not destroying walls. It's not causing fires. What it's doing is it's impacting employees or it's impacting customers. It's not that simple. And what the insurance companies are beginning to see is a pushback to that position. And I'll get into that later on in my presentation. But the takeaway that every business should know is that depending on what state you're in, the law may be different on the physical loss or damage to property issue. And it also may be unique to your type of business. Some of the legal arguments regarding physical loss. The predominant type of argument that lawyers against the insurance companies are making relates to the civil authority shutdown orders. And the civil authority shutdown orders, whether it's the governor or here in Chicago, city of Chicago, they're saying that is not creating a physical, that is creating a physical loss to my property. I'm not able to access my property. That is one camp. The other camp, the other legal argument is the damage to property. In the past, we've not seen a crisis like COVID-19 in any of our lifetimes, at least I believe so. But in terms of the legal environment, the last crisis that we saw that caused an uproar amongst the insurance sector and the interpretation of policies related to asbestos. And in those types of cases, the insurance companies argued that there's no damage to the property. Asbestos might have been in the air in a building, but and that didn't create damage to property. Asbestos is only damage to property if you disturb it and cause it to rise in the air. Well, prior court decisions came out and said no, the mere presence of asbestos did create damage to property. So that's the type of contrary legal arguments that the insurance companies are being faced with. Then the other issue we have is whether you're a fan of the President of the United States or not. He came out in a press briefing on April 10th, 2020, and said, with regard to businesses, when they finally need it, insurance companies say we're not going to give it. And he's talking about business interruption insurance. He says, we cannot let that happen. When you have, the President of the United States coming out and saying that, who is the chief executive, who can influence policy, and the bottom line is laws impacting insurance are being changed on the federal, state, and the local government level. Policy interpretations are being challenged in the courts. Already, to date, new laws have passed. There's at least over 50 bills at the federal level, including a bill that was modeled after the post 9/11 bill, and that is called the Pandemic Risk Insurance Act of 2020. And that's widely to shield large and small businesses against the ravages of the pandemic that we're facing. At the state level, given your state, there's over 30 states. Your state is probably one of them. Since I drafted this presentation a few weeks ago, the number of states probably has increased, but at the time, over 30 had already passed unique laws to respond to the crisis. Some of those related to health insurance, others related to potentially business insurance. On top of that, almost all states have additional laws that are pending in their legislatures due to the crisis. Some of the ones that are particularly relevant to today's presentation and potentially to your business are the ones that were pending in Ohio, Massachusetts, and New Jersey. Those are bills that are threatening to make business interruption coverage mandatory for COVID-19 claims. And then on top of the legislatures, you also have the insurance regulators in each state. And the insurance regulators are rolling out guidance and modifications to existing insurance plans, and they're advising insurance companies that what they have to do. So what does this all mean? Well, the insurers have come back with their main arguments against these retroactive types of new laws. And so they'll be overwhelmed with the amount of claims, and they would need their own federal bailout. They're also arguing that, insurance policies are contracts at the time they're written. This is what both parties agreed to. We did not agree to these new laws, and therefore, any type of COVID-19 coverage was not meant to be included at the time of the issuance of the policy. Well, the problem that insurance companies are going to have with that is within the policy, there is typically, and again, remember, the main theme here is read your policy, read your policy, read your policy. But there's a conformity of statute term, and the conformity of statute term states if the law of the state that applies to this insurance policy is contrary to what's stated in the insurance policy, the law of the state will control. So those are things to keep in mind. And what's going on in the courts? Well, I'm a litigator by nature. For over 20 years, I've litigated different types of commercial litigation, but I started in insurance defense and insurance coverage, and have consistently advised clients on insurance issues. And I've litigated, and I'm litigating currently in the courts over insurance issues. And I will say, in my experience, I have not seen such a large influx of filings in the different states, in the different industries, and it's only been, probably as of this broadcast, within 30 days of the, within 60 days of the crisis. Here in the Midwest, we have lawsuits that have been brought by restaurant and theater owners. We have dental offices. We have class actions being threatened by plush toy manufacturers. In the East, there's scuba shops that have filed business interruption coverage claims. There are sports facilities, obviously many manufacturers and many different types of bars and prominent restaurants. And I cannot stress enough that this is not normal for litigators to see this scope of litigation and how it's affected so many different industries. So I encourage, if you're a business owner, I encourage you to call, your trusted advisor to talk about these issues, to see if you're one of those industries that's been impacted. Don't just take what's on the internet. Talk to an experienced professional. So amid this backdrop of the new laws coming out, the President of the United States saying there must be mandatory coverage, the legal battles in the courts across, probably all 50 states or almost all 50 states. What do you do in all this uncertainty? Well, it's a very simple answer, and I have yet to have said to a client the opposite to the following advice I'm going to make right now, which is make the claim. Whatever your business is, if you have a property policy with business interruption coverage, especially, make the claim. There should be no harm in doing so. Talk to your insurance broker. that is the one issue that I can't stress enough as you leave today's webinar. So what insurance may provide coverage for a business's losses? So there's many different types of business property insurance policies, and they're written in different ways. Different industries have different ways in which they call their policies. It's like reading Greek to some people, which for me, I'm Greek, but no, just kidding. I am Greek, but the policies are still very dense and very hard to understand, even for some of us professionals. The most sought after policy in retrospect you would have wanted pre-COVID-19 is what we call all risk coverage. And I call it the insurance unicorn. You know, you have these businesses that are called unicorns from Silicon Valley. You know, is it $1 billion business? And I'm saying for COVID-19 business interruption claims purposes, all risk coverage that contains no exclusions is the insurance unicorn in this setting. It's property insurance that covers losses from any cause that's not excluded. Opposite to that is something called named peril coverage. And named peril coverage is only insuring for causes that are listed in the policy. So you may have a policy that says I am insuring for virus contamination, or I am insuring for pandemics. Those types of policies are a little bit more uncommon. And then within your property insurance policy, and I will say the majority of clients, at least that I've advised, and then my partners have advised here at HMB, have property insurance, and within the property insurance policy is the business interruption coverage or the business interruption endorsement. And that is the type of coverage that most businesses are seeking today as a result of COVID-19. Those policies relate to providing reimbursement for rent, lease payments, relocation costs, loan payments, taxes, fixed costs, lost revenue. I mean, it depends on your policy. Net income is one of the major claims or major definitions within the endorsement. The second most relevant coverage that I've referenced earlier today, but that usually is in a property insurance policy for a business, is what we call civil authority coverage. And that reimburses for lost profits and other economic losses when a government issues a legal order that results in your business being shut down or severely impacting your business. It really just depends how your policy is written. Unfortunately, I'm going to keep saying it depends how your policy is written several more times throughout today's presentation. I apologize in advance. If you're a builder, you'll have a builder's risk policy. Then there are other types of policies that I won't get into because I don't want to bore you, but there's ordinary payroll coverages, extended period of indemnity coverages, also contingent business interruption coverage. I'm going to pause here because contingent business interruption coverage is when, let's say you're a restaurant and you're in an area where all your food suppliers have been shut down because they've had a COVID-19 outbreak. And so you cannot get your food supply, you cannot get your materials that you need to run your business. Depending on how your policy is written, you potentially have coverage for that via the contingent business interruption coverage in your property policy. Then there's contingent extra expense. That's if you had to go outside your normal group of suppliers and go to a different customer supplier, and that resulted in extra expense or cost that was significant enough to make a claim under your policy. Then there's also Ingress and Egress coverage, which, as it sounds, if your property is shut down, the ability to access your property is shut down for some reason pursuant to a government order, or just the realities of somebody having COVID-19, that could potentially provide coverage. Then there's extra expense coverage, which is another layer of coverage that typically follows business interruption, and that's for non-ordinary expenses after an incident like COVID-19. Then there's, pollution, contamination, and environmental coverage, which you would think this type of pandemic would clearly fall under. But again, you have to read your policy to know exactly what type of coverage is allotted. A lot of times that's for cleanup costs because there's a pollutant or contaminant on your premises. What we're seeing for a lot of our business clients in the manufacturing area, they're in the manufacturing fields, they're spending upwards of $30,000 to $50,000 to clean their facilities because somebody who was present who was an employee or a vendor said, "Hey, I was at your property, I was at your manufacturing facility, I had COVID-19." And if you hear that and you knew you had an active case, many times, and consult your trusted advisor before doing this, but many times the facility's shut down and a specialized cleaning company comes in. The cost for that is extensive because the services are extensive, which are more than $30,000, could be up to $100,000 or more, depending how large your facility is. That's where you should look for your pollution and contamination and environmental coverage. Also, there's crisis management coverage, although crisis management is more of a coverage that is when there's a widespread disaster and you need to communicate to the public, and you have to hire someone to communicate that you've been impacted and what needs to happen. That may happen if you're in the context of COVID-19. Let's say you're a food manufacturer and you have unfortunately had COVID-19 on the premises, and you believe that some of the food that you've put out to the public has been contaminated. This coverage might provide you with somebody to assist in notifying the public and the crisis. Again, read your policy. Then the last type of coverage that I'll talk about is event cancellation insurance. Very easy to understand what that typically is. For whatever reason, you've obtained event cancellation insurance due to COVID-19, you had to cancel the event. There's going to be an issue of are you postponing the event, or are you just canceling it outright for that year? Again, this is where you're going to have to read your policy closely and lean on your trusted advisor to make that determination. And you have to be careful in how you communicate to the people that were going to attend the event so that you aren't potentially negating coverage, or when I say negating coverage, I mean, hurting your chances of obtaining coverage because of the way that you may have communicated the cancellation of that event, instead of using the words that might have been necessary pursuant to what's in your policy. I would, in those situations, lean on your broker. And in all situations, that's my takeaway here with these policies. My first piece of advice is not, aside from make the claim, my first piece of advice is these business policies are complex. You need to lean on your broker. And you lean on your broker to the extent you can, because sometimes people just buy policies and then they really don't, they buy it via the internet, or they buy it through a very relaxed medium, and they don't have a close relationship with their broker, or they don't have a clear line of communication, so they don't have a broker to lean on. And then in that context, I would say lean on your attorneys. And they will hopefully get you the right answer, like the attorneys here at HMB. And so what other non-business interruption insurance policies could businesses have that might be triggered by COVID-19? So this is, we'll get into this in more detail later on in the presentation or in a subsequent slide. But this is, depends on your business's industry and what policies you've already purchased. And that includes the types of policies I'm thinking of, which would be triggered by third parties most of the time, are your directors and officers, your errors and omissions, your professional liability, your CGL policy, as it's commonly called, which is your commercial general liability, your umbrella policies for all that you may have under your CGL or all these other policies, your pollution policy. And earlier I was talking about first party pollution policy coverage. Now I'm talking about third party pollution coverage. Then your employee benefits liability, your workers' compensation, and your cyber liability. Are businesses adequately protecting against remote working losses or cyber incidents? I am going to say, without moving to the next slide, no. The concerns due to this new working from home environment, employees working remotely, are triggering so many insurance related issues that people weren't thinking of prior to the crisis. So, one of the first things I encourage businesses to do is verify that your workers' compensation policy applies to your new employees that are working from home. You need to be aware of exclusions, not only in the workers' comp policies, but in your property policies of your non-owned company equipment, and that also reminds me the exclusions in your cyber coverage. And what we're talking about is in these types of policies, for example, let's say you have an employee that was at work and they received an email that was a spoofed email that wasn't a true, wasn't from a true vendor, and responded to that email, and that might have caused someone to make a payment to a fraudster, a fraudulent, an imposter of the true vendor, and money had changed hands and there was an actual loss, and that happened at work on your work computer. Well, you have cyber coverage, hopefully, for that type of incident, and there would be coverage for that. However, if you're now working from home, you have employees working from home, and that same employee was working on their, their, let's say they had a work laptop, or maybe they were never issued a work laptop and they were using their own home device. Well, the insurance policy that you have, your cyber insurance policy, might not provide coverage in that instance, because it will say you need to have all employees, you've made the representation in obtaining this insurance that all employees are operating on company issued equipment. And that might be an automatic denial. Or what would be a little bit more common example of the risks is, let's say you have an employee working from home who has a laptop that doesn't have all the updated security settings that if she was plugged into her network at work. Doesn't have the necessary firewalls, doesn't have the latest patches. And let's say his or her laptop was compromised and hacked into, and there was a loss that created out of that event. I would not be surprised if an insurance company denied that claim to say you weren't on a network that was protected by your employer. You did not have all the up-to-date fixes per your company's policy. So these are things that you have to be mindful of. I have another cyber presentation that you should look for that gets into more detail on those issues. So if you're interested, look for it. Businesses are also now doing deliveries as part of just basic survival. So you have restaurants that might be repurposing their employees and having those employees now become delivery drivers rather than using Grubhub or Uber Eats or some other mechanism, because they want to give their employees a job, which sounds great, right? Well, did you check your commercial general liability policy and your workers' compensation policies to see if there's coverage for this new activity? Remember, as a business, when you apply for insurance, you tell them what the scope of your business's activities are. If those activities have changed now to COVID-19, and whether that's delivery drivers or people working from home, you need to alert your insurance carrier and either get the right type of endorsement or get verification in writing that you're covered. Another huge point is verify that your umbrella coverage, first of all, I assume you have umbrella coverage. If not, go get it, and then make sure that it applies to all areas of all different types of insurance that is being impacted by COVID-19, the new working realities. So that's your workers' compensation and your auto coverages. I already mentioned cyber events. They're up more than 600% during this crisis because more people are online, obviously. There's more spear phishing, there's more malware, there's more spoofing of email accounts. My recommendations for all my business clients and for anyone that's watching this webinar is make sure your HR department should carefully review its employee handbook and make sure it's updated for the new realities of remote working. And so that's step number one. And number two is make sure the employee handbook has been circulated and employees are told, hey, just because you're working from home doesn't mean the handbook doesn't apply. Your businesses should also have your IT departments re-examine and verify that each remote employee's each remote employee of the business has the proper firewalls set up at home. Obviously, this is an enormous task. If you're a company with 100 employees that are now working from home, you're going to say, how can I, it was hard enough when my IT professional was monitoring our one network in our office. How does he possibly monitor 100 networks? Well, there are some simple guidelines that can be issued by HR, by the IT department, to make sure that those that security best practices for security on cyber issues is being adhered to. And I encourage you to reach out to your attorney if you need to know more about how to roll that out. Also, accounting departments need to put all the employees, all their staff on high alert as to the payment process and how the payment process you should have a multi-factor authentication process for getting paid or for making payments. Make sure that's strictly adhered to. Maybe you need to add a third authentication process. This is the time to carefully review those internal policies and to make sure they're followed. Reopening, renewal, policy expiration, and other COVID-19 insurance issues to be aware of. As businesses begin to reopen to the public and bring back employees and clients and vendors are preparing to visit business sites, there are some other critical COVID-19 insurance issues they need to be aware of. And you might be thinking of a future business interruption claim caused by COVID-19 or another health crisis, but you should also really consider the impact on your commercial general liability insurance policy, your CGL policy. And that protects against third-party claims. So the most frequent example I give is a restaurant serves a meal to a customer. The server or one of the cooks may have had actually COVID-19. The customer becomes ill and suffers medical damages or worse. And then either the customer or their family makes a claim against the restaurant, saying, hey, you caused this medical problem and you're responsible for it. So that triggers what a business normally has is their CGL policy. And under that policy is a term defined as bodily injury. And the bodily injury coverage is sometimes there's an exclusion that goes against that coverage for losses due to virus. So just imagine in this COVID-19 world, if you're a restaurant, you have that type of policy, or obviously you're going to have a CGL policy and you have that exclusion. So the number one thing you need to do is either you need to do it, your insurance broker should for sure be doing it, or if you're not comfortable reading your policy, you don't have access to a broker, then you need to lean on your attorney to do it, which is look for the standalone, look for this language, look for a standalone endorsement. Sometimes these exclusions are part of a standalone exclusion for bacteria or fungus, or part of a microorganism or contaminant exclusion. And then what you need to do is, in order to get ahead of it, you need to reach out to your insurer and say, hey, I want to make sure I have coverage for these potential type claims. And then if they say no, then you need to do your best to try to get coverage from a new provider. Remember, even if you're mid-year in an insurance policy, you can always cancel that insurance policy and get reimbursed for anything you might have paid in premium going forward for any future part of the term, and you can switch carriers. And I'll get into some of the issues regarding getting new coverage in the next few slides. Also consider, in relation to your CGL policy, any pollution exclusions, because those will potentially be used against you by an insurer. Some practical concerns when you receive a notice of a claim of someone saying they were injured by you due to COVID-19, whether it's, like I said, a customer at a restaurant, but think about, even a client at your law office, God forbid, or dental office or somewhere like that. You need to start a written investigation immediately. You need to alert your carrier immediately. I would alert your broker immediately, your attorney immediately. Usually clients alert the broker and the attorney in the same email or phone call. Do not wait 24 hours. I hope I've expressed the urgency enough. I'll move on. There's also an impact that you should think of when reopening on directors and officers, errors and omissions, and other professional liability insurance policies. Claims could be made against managers, directors, officers, or professionals for failure to make decisions to make the workplace safer, make your offices COVID-19 free for purposes of guests, whenever that happens. Ensuring a safe workplace for your employees. As I just mentioned, there are some other issues that come up when you're renewing or getting a new policy, or your old policy is expired. And at a minimum, I'm just going to lob the softball issue out there. Be aware of any new virus, pandemic, or COVID-19 exclusions. It's an interesting time right now because insurance companies, as you know, are fighting, and almost every insurance company, I'm going to guess, within the year that has written a business interruption policy in the United States will be subject of some type of litigation, or will be impacted by some type of litigation. So, the question becomes, if I'm an insurance company, do I now write a new policy or a new exclusion in my policies for future COVID-19 issues? So it's, without a doubt, COVID-19 is not a covered issue. Or if you have COVID-19, if you want COVID-19 coverage, you need to pay an extra exorbitant premium because of the loss could be so big. Well, that creates the issue of impacting all these current lawsuits you have out there. So policyholders could therefore, just theoretically speaking, could therefore say, if you're changing your insurance policy going forward, that means your old insurance policy, all the ones that are stuck in the lawsuits, but that are subject to class actions, that means there was coverage. So it's a very slippery slope here. I would not, I'm not envious of being an insurance company these days. On that note, the ISO, as it's commonly referred to, which is the Insurance Services Office, is something we should talk about. And that's a private company that serves the insurance industry, the insurers directly, the reinsurers, the agents, the brokers, the regulators, and they develop model forms. They've already rolled out 2 advisory forms that would provide coverage, limited coverage for COVID-19 going forward. We don't know, I have not seen that actual form being adopted by any carriers yet. And what, it's unclear what they're going to charge for that type of coverage, and what coverage is going to be, what's that coverage going to look like. I've included a link here that you should utilize for any changes, any up-to-date revelations on that issue. But lean on your broker in that instance if you're renewing or buying new insurance or need to get new insurance. And then another issue that is really dear to my heart, and I know you might be thinking that you feel sorry for me that insurance issues are dear to my heart, but I tell businesses almost on a daily basis to make sure they look at their claims-made coverage policies. And what is claims-made coverage? Well, this is something you find in professional malpractice liability, sometimes D&O, E&O, fiduciary liability. But most times you find claims-made coverage in employment practices liability. So in this post-COVID world, where COVID-19 world, where employers are issuing layoffs because they can't support their staff for whatever reason, or some employees may think or may actually have a claim against their employer saying, hey, you shouldn't have fired me or let me go. You should have fired somebody that was, more junior to me, or whatever the reason, that person has. Maybe they say they were discriminated against. Well, if that type of claim, you receive that type of claim, and that might emanate in a letter by that employee, that may be from their attorney, that might be by an EEOC complaint. Here in Illinois, the city of Chicago has its own enforcement branch protecting employees, and you can make claims via the city of Chicago. And in those settings, you need to alert your insurer immediately, because claims made policy, unlike the property insurance policies we've been talking about, you have to make the claim within the policy period. In other words, if today is May the 12th, and you have a claims made policy, that an employment practices policy that expires on May the 15th, and you receive a letter today on the 12th that somebody's going to be suing you for discriminatorily discharging them, then if you wait until the 16th to make that claim, in some policies, that claim is something that is going to be denied because it wasn't made prior to the 15th. In other words, the effective date of the policy was May 14th, 2019 to May 15th, 2020. If the claim doesn't get into the insurance company's hand before that expiration, and you knew about the claim, it could potentially be denied. Now, there's another issue about extended reporting that's in a lot of these claims made policies. So maybe take a deep breath, lean on your broker, lean on your attorney, if your broker is not around, to find out what needs to happen. Sometimes there's also a situation where you think somebody's going to make a claim, and maybe they haven't articulated it clearly, like, I'm going to sue you or I am damaged, and you have a claims made issue. You should be aware of what is called a notice of circumstance, and strongly consider filing a notice of circumstance, or writing a letter, or having your broker or your attorney write a letter to your insurance company saying, I don't know if this person is going to actually sue me or file a claim or further pursue this, but this is a notice of circumstance. And what that does in a claims made policy is that hopefully and should make a retroactive claim within the policy period, meaning if today on May the 12th, you send the notice of circumstance in your policy that's expiring on the 15th, but you actually don't get the lawsuit for 2 more months, you shouldn't be denied that claim because you already told your prior insurer within the claims made policy. So now that I've bored you on claims made issues, also think about, changes, if you're renewing your policy or you're taking your policy to another carrier and say, oh, I had all risk coverage with Hartford, and now I'm going to, the Hanover Insurance Company, and you think, oh, I'm covered in that, with my insurance unicorn, as I've called it in the past. Well, all policies are not the same. Especially among carriers, even within carriers. So make sure you understand your policy, get it in writing. I can't urge clients enough to get policy interpretation and coverage opinions to the extent you can. Insurers are reluctant to say, here's my here's a fact scenario. Do I have coverage for it under my new policy? My advice, again, lean on your broker, and if your broker is not there, you can lean on us or a qualified attorney. The importance of tracking expenses and damages during COVID-19 and other resources for these COVID-19 related losses. So I'm going to give you a softball question here. How important is it for businesses to start tracking expenses and potential damages for COVID-19 from now? And what should businesses do if it is important? Well, it's extremely important. And I know you knew the answer to that. And retaining documentation is key. Prior to COVID-19 and the current crisis and then wave of insurance litigation that we're now seeing, a frequent way that insurers were using to defend claims brought by business owners was to say that the documentation was inadequate and we can't, pay on a poorly documented claim, because businesses, what does a business do? They operate their business. They don't think about their insurance claims and how to perfect them. And so what you need to do is create, perhaps designate one person within your business to track your losses and your expenses related to whatever the claim is. And I would highly recommend giving someone that duty within your company. And that way you've, done your best to preserve your rights. And so any claim that you've waived your rights by not having adequate documentation is thoroughly taken care of. Some of the tracking suggestions we have for business interruption claims is, track and identify lost profits and sales during the period of loss. Another thing people aren't thinking of is keep track of industry data, market demand, and trends. Direct and indirect cost savings. You now, instead of having to go to a supplier in Indiana, a state away, if you were operating in Illinois, now you have to go to California, and the increased costs there. That also goes to, which customers you've lost, key customers, and keeping track of those. Your historical, operational, and financial records. Make sure that if you have not in the slides, but something to be aware of is if you have auto delete policies or deletion policies for different reasons of your financial records and your historical patterns or your emails, you might want to rethink those auto deletion measures to preserve that data so that you can use for your claims. And that, those are things such as, the influx of customer requests and pre-COVID and post-COVID. Well, you need to have those prior emails to show what that looks like. And then depending on the complexity of your claim, you might want to retain a third-party claim consultant. Some people's policies have that type of coverage, so you don't have to incur that cost or have that cost go against your claim. That can actually, your potential claim, that can actually be a separate coverage under your policy. And what do you have to do to find out if you have that type of coverage? You have to read your policy. Or have your broker read your policy. That third-party claim consultant might create a business interruption valuation report. This is where it gets complex. It's like, well, how do I know what my claim is going to look like? Well, that's where you might need a professional in businesses that have multi-factor issues to figure out their net income or whatever is covered under the policy, because again, each policy is different. So because you have business interruption insurance doesn't mean you have the same type of losses that will be covered between different types of insurance policies or insurance producers. So the Hanover might provide for net loss on some other formula compared to CNA or the Hartford under the policy that you have with them. One final note, businesses that are especially impacted by COVID-19 and need funds immediately, they should think about making partial claim submissions from now, instead of waiting and gathering all this data and then say, look, I've lost, COVID-19 is now over, and wait, let's say a vaccine is developed, and hopefully it will be, and it's developed 2 months from now, and then you have a finite period of when your business was impacted. Well, you might want to you might need to make a partial claim submission from now and submit documentation as to your losses and your expenses and say, I want to get reimbursed at least, or not reimbursed, but I want to get paid at least this amount, because even though I'm going to have more losses, I need the money now for business operations. You might have that right under your policy. And some insurers, out there may react quickly and provide partial reimbursement and for optics reasons, they might want to do that as well. What other resources are there that might provide relief for COVID-19 and its related losses? Have you thought about if you're an additional insured on other people's policies? So a lot of times landlords will make sure their tenants are additional insureds, not exactly sure what those coverages and how they interact. You might not be aware how they all interact. That's why you should lean on your broker, but you should think about in the past year, or what I suggest to my clients is that they do a contract audit and figure out and check the boxes and say, okay, I have contracts that are outstanding that are still effective with 50 companies. Well, with these 50 companies, or more likely like 10 companies, am I an additional insured for whatever reason on those policies? And then also, while you're doing that contract audit, look to see if there are indemnification provisions or force majeure provisions. At HMB, we have we have other resources that you can find on our website on both indemnification and force majeure. So if you need other resources, I encourage you to look there. And then, the other areas that everyone who's watching this knows about right now are the big federal acts, the PPP that comes from the CARES Act. But then, aside from those big programs, think about, state, local, and even private industry relief programs. There are the hotel industry has special relief. Airbnb has its own relief program. What I've listed here on slide 22 are some resources, some great resources, comprehensive resources that you can consult to see if there are federal, state, and local relief programs that might affect you or your industry. Minimizing risk against employee claims of COVID-19. What should businesses do now, right now, to minimize risk against potential employee claims from someone becoming ill from COVID-19? Now, this is just a very high level presentation on this issue. I encourage you, if you need further guidance, or I encourage every business to consult their attorney and to ask the question, what else should I be thinking of with respect to my specific industry and my specific business and my specific locality? Because what I'm about to get into is a general summary and is not going to account for all those different factors, the size of business and your business relationships, and where those employees, where you're sending your employees and how they're interacting. But very basically, at a high level, have proper reporting policies in place. Those are typically anonymized. So for instance, you have emails that can be sent to HR or the appropriate management of your business that alert that an employee is sick. Be aware of the different acts that still apply, which is the, I'll just highlight a few: the American with Disabilities Act, the Age Discrimination in Employment Act, the Health Insurance Portability and Accountability Act, Hipaa. Those concerns as they relate to some examples of those concerns as they relate to COVID-19. You need to treat with ADA and ADEA claims or potential claims or concerns. You need to treat all employees equally and apply the policies non-discriminatorily, both obviously during the pandemic and when the crisis is over and the workplace returns to normal. You may be thinking of sending, for example, maybe thinking, we know that COVID-19 especially impacts people over a certain age or older people, like myself, no, but they do. I am 49 years old. My wife likes to say that I'm 50, but I believe there's material out there that says I am in a heightened risk class. So think about someone of my age being told, Bill, we're sending you home because we don't want you to contract COVID-19 in the workplace. And we know you're part of an older age group and therefore you're susceptible. Well, that I might potentially have an age discrimination claim in that context. Consult your attorney to find out how you navigate through those issues and what you have to say, or what you need to say, and what your thought process should be in guiding your decisions. And the other issue is HIPAA. Employers are required to obtain or maintain confidential the medical information they receive about their employees. You have to be careful when you have incidents of COVID-19 and telling people that there's COVID-19 exposure at your business, and making sure that it's as anonymous as it can be, given the setting or given the communication. so that people can't say, oh, you violated my Hipaa rights, because it's easily determined it was me that I had COVID-19. So, you can't, anticipate every issue, but there are some pretty big issues that you can anticipate, and that's what we're talking about here. Make sure you've insured your business. Make sure you've informed your employees of their rights under the various acts that are being rolled out, the modifications to the employment laws, and confirm that they're in receipt of those their new rights, and the Families First Coronavirus Response Act. That's one to note, that has the expanding paid sick leave. That impacts FMLA, obviously, or there are impacts to the FMLA that you need to be aware of as an employer or business. And since the requirements at the federal, state, and local level are constantly changing, and what you should do, how you should manage your workplace, how you should distance your employees, I again suggest designating, one or two people, depending on the size of your business, and maybe it's a whole team that is responsible for monitoring updates by the CDC and other local health departments. For instance, here in Illinois, I'm in Chicago. Not only do I think about CDC recommendations, but I also think about the mandatory guidelines of the City of Chicago, the Illinois Department of Health, the Cook County Department of Health. You have to be aware and should monitor it. And then obviously we have the the original employer minimizing risk warning that came out through all of this pandemic, which you should tell your employees if they have a cough, fever, difficulty breathing, they should stay at home and not risk exposing others to illness. Again, you should be checking all your local ordinances on that point. And if all of the above that I've just talked about in the last 5 or so minutes is not followed, either you might be hit with a business employment practices liability claim or an employee benefits insurance related claim. And therefore, remember, those are at least with the employment practices liability coverages, those are claims made. And so you need to be especially cognizant of that. So some closing thoughts. This is just the beginning, unfortunately. There are going to be so many changes from various sources, lawmakers, regulators, judges, insurers, the insurance industry. We don't know exactly what this is going to look like 1 month from now, let alone, a year from now. My advice is to, my advice to every business and to every fellow person on this planet is to stay in touch with their business partners. Check your industry resources. They're invaluable at times. And then, of course, your trusted advisors, your attorneys, your bankers, your lenders, your financial advisors, your accountants, and your sophisticated insurance brokers. Together, we will, hopefully we can guide each other through this process and be better prepared in the future for another, God forbid, another type health crisis, and to deal with this current crisis. I thank you all for listening. I hope I didn't geek too many of you out on my insurance issues. On that note, if you want to talk to me, feel free to email me, call me. I will try to get back to you as soon as possible. I'm here to help. I love helping people, and if I don't know the right answer, I pride myself on trying to get you to people that do have the right answer.